An investment in knowledge pays the best interest. At the beginning of every case, both the lawyer and the client engage in a tremendous amount of fact-finding. It can be overwhelming at the beginning of the case for the client with all of the information they are receiving from the lawyer. Likewise, the lawyer has to engage in rigorous fact-finding so they can have all of the information at their fingertips. Usually what will happen is the lawyer and the client will sit down at the beginning and go through some sort of family or marital history. This enables the lawyer to get all of the facts in one sitting and usually helps the client be able to process any questions that they may have at the outset. There will be a series of meetings, phone calls, or video conferences whereby the lawyer and the client discuss any relevant questions that either of them may have and develop the strategy for moving forward. One of the questions I always get asked is, how quickly can I move this case along? Honestly, the answer usually depends upon how fast the other side is willing to move, if the parties are going to engage in a dispute resolution setting. Dispute resolution procedures are entirely voluntary. That's very important to understand. Mediation and collaborative law are engaged because both parties want to participate in the process, as opposed to litigation, where one party may choose to file in order to move the case forward. Usually, if the parties choose dispute resolution, the case will move rather quickly because both parties are aligned in their objectives. After all of the fact-finding is completed, the lawyer needs to distill down the salient facts so a strategy can be developed. It is up to the lawyer to take all of the facts and apply it to the law and educate the client on possible outcomes in court. This sometimes can lead to difficult conversations between the lawyer and the client when the lawyer has to apply the law and tell the client that his or her desired outcome may not actually be achievable. This is the point in the case when several different options are becoming more clear. This is also the point in the case where the client will probably have several questions about what legal strategies could benefit them and what other legal strategies could hurt them. There are two different elements at work here. There's the emotional and there's the legal. Let me give you an example of something that is not atypical. If someone inherits property during a marriage, depending upon several circumstances, it is likely that that property will remain that person's non-marital property, even in the event of divorce. That is a difficult concept for clients to understand. For example, if someone used their inheritance to buy other property or support the family, it still may be their non-marital property at the end of the case. What this means is that they will be able to take that property post-divorce as theirs 100%, and the other spouse may not get a share of it. As you can see, there is both the legal component and the emotional component, and they are incredibly intertwined. You as the client are going to have a very difficult time unraveling the legal from the emotional. It is your legal partner's obligation and responsibility to help educate you on what the law is, but also support you emotionally. Unlike other lawsuits, the facts in a divorce case can change constantly. What is going on in the beginning of the case may resolve itself, or it may evolve into another set of circumstances that need to be addressed by the end of the case. Likewise, a client's goal can change throughout the case. If the client's goals change, it's critical that their attorney be up to speed on what they really want. Even if the goal changes to they don't know what they want anymore, that is important to let your attorney know. It is critical for the client to be educated and empowered with the law and the facts so they are in the best position possible to move forward in the negotiation. It is so important for clients to ask questions of their attorney before going into the negotiation room. Sitting down at the table and negotiating your deal is the time where you should be thinking about what options are on the table and what the best outcome for you is. Asking questions before you get to the table will allow you to process those answers and possibly brainstorm different solutions with your legal partner. Knowledge is power. It is up to you and your legal team to make sure you have all of the information you need before you go to the negotiation table. Follow me on LinkedIn or visit my website for more insight on finding your legal partner.